Hello. This is another presentation from the Van Winkle Law Firm Trust and Estates Group with various topics about estate and tax planning. And today's topic is tax planning, which I think is something we have not covered yet in these various presentations. My name is John Kelso. I am a partner in the firm's Asheville office. I will be joined soon, I think, by John Veazey, who is a partner in the firm's Hendersonville office. And before we get started with the substantive part, the usual disclaimer that today's presentation is based on general North Carolina law and federal law and our own experiences in client cases that we have worked on, but this presentation should not be considered legal advice and is not a recommendation for any particular strategy or action on part of any client. So you would need to consult with an attorney about your own circumstances before taking action on any of these things. So today's topic generally is going to be about tax planning matters, and not just estate tax planning matters, because as we'll get into in a moment, estate taxes are applicable to a very small percentage of estates and people. Only if you have a net worth over roughly 11.5 million if you are single, or approximately 23 million for a married couple. So that's not too many folks who would have that need for tax planning. So we are going to touch on that, but also talk about income tax planning, planning for reducing capital gains on inheritances by the beneficiaries afterwards, maximizing deductions, etc. So we'll try to make it a little more relevant to folks who don't have $10 or $20 million estates. And when I say a net worth of 11.5 or $23 million, I do want to make it clear that when we say an estate of that size, it's not just the probate estate, but also anything that the decedent owns or controls. So that would include life insurance, IRAs, other retirement accounts, anything that the decedent could be said to own, even if it is not part of the probate estate. So different meanings of those words. And there is John Veazey. But John, before you get started, let me cover one more topic here.
Sounds good.
So the current exemption levels, as I mentioned, for this year, 2020, it's $11.58 million for an individual, which translates, of course, to about $23 million for a married couple. Next year, it will increase by an automatic inflation adjustment to $11.7 million for an individual. And these exemptions, we think about it as an estate tax exemption, but it could also be used for lifetime transfers if you make gifts. So if you make a large gift, let's say you gave away $1 million this year during lifetime to your children, then that just reduces the exemption available to your estate at death by that $1 million. So they track both things to make sure that whether it's a lifetime gift or an estate transfer, the total is not more than that exemption amount. And I mentioned that it affects only a very small number of people. And just to put that in perspective, according to some data prepared from IRS information, less than 1 in 1,000 estates is a taxable estate. So that's less than 1/10 of 1%. One general rule that applies is what we call portability of the exemption between spouses, which means, so a little lingo here in the estate planning world, we talk about the first spouse and the second spouse of a couple. So the first to die and the second to die. So upon the first spouse's death, what often happens is assets are just left outright to the surviving spouse. So that does not use up any of the first spouse exemption. So then the first spouse's unused exemption, the 11.5 million or whatever it is, can now be used by the surviving spouse in addition to their own exemption, so that when the surviving spouse dies, they have the total of 23 million or whatever that is. But the portability is not automatic. There has to be a federal estate tax return filed after the first spouse's death, within 9 months after the first spouse's death. to tell the IRS whether any exemption was used, how much, and then how much unused exemption remains available to the surviving spouse. Those exemptions will sunset, is the term we use in the tax law, in 2025, at the end of 2025. And the exemptions will, even under current law that's been enacted, the exemptions will be cut roughly in half at the end of 2025. But of course, the law is probably going to change before then anyway. So, John, I think you're taking the next topic there about cost basis.
Thanks, John. I'm going to cover a couple topics that are more along the lines of income tax issues, and I think they're a little more broadly out in that I think we would find that almost any estate would have some level of the cost basis adjustment that would come into effect. What it's typically called is the step up in basis at death. What cost basis means generally is if I buy a share of stock in Amazon for $10 and over time it grows in value to $100, my basis in that stock is $10. If I sell it for $100, then I have a $90 capital gain that I must report as income. On the other hand, if I pay $10 and the stock goes down in value to $1, I have a $9 loss that I get to use to offset other capital gain that I would have to report. The law is different in this case regarding basis, depending on whether you gift property to someone during your life or whether you gift it out of your estate. So if I gift property to someone while I'm alive, it maintains a carryover basis. So if I bought that Amazon stock for $10 and it's now worth $100 and I gift it to my son, he has a stock worth $100, but his basis is $10. So if he sells it, he'll have a $90 gain. On the other hand, if I own it when I die, then the basis in the stock will be adjusted to its fair market value at my death. So the basis will become $100. My son will have the Amazon stock with a $100 basis. He can sell it without having to recognize and report any gain. So this is a really good benefit for people and something that we try to plan with in almost all of our cases. One quick point, although it's called a step up in basis because most of the time people hold on to assets and they grow in value, it's not only a step up, it is a step down. So if you have property that as a lost property where the current value is less than what you paid for it, and you die owning that property, the basis will be adjusted down and your beneficiaries will not have the ability to claim the loss if they sell the property. So what we generally try to work with people on is we try not, if we're dealing with the income tax consequences, to have them gift property that has high appreciation in it. That would result in the carryover basis and would result in their beneficiaries needing to pay income tax. That if instead those individuals held on to the assets until their death, that adjustment to the basis would disappear. We also have a situation, I think John covered at the beginning, where recently the estate tax exemptions have gone up somewhat exponentially. And so we come across a lot of times where there's planning that has happened, and John's going to touch on this a little more later, but planning that would have created a trust, for example, to avoid estate tax that's just no longer an issue. And if you have those trusts, you won't get the benefit of the step up in basis. So we try to figure out if we can add things called powers of appointment or otherwise modify the trust when we no longer have estate tax concerns so that we can address the capital gain issue. I'd also point out, as John pointed out with the estate tax, there is some talk now of eliminating this step up in basis. I'm not sure how much traction it will have, but it comes up every once in a while that that some people believe that it is just a free gift that should be eliminated. So we'll have to stay tuned, but under our current laws, we're able to deal with this cost basis adjustment. The second sort of income tax consideration that I want to touch on that I think will affect a lot of people has to do with certain assets that have income tax consequences that do not go away when an individual dies. For instance, retirement accounts, traditional retirement accounts, and even in some annuities. And what I mean by that is, if you have a traditional retirement account, you have tax advantage benefits when you contribute to that account, and the amount you contribute, you're not paying income tax on that money when you contribute it. You have tax-free growth and appreciation within your retirement account while you're alive. And in exchange for those benefits on a traditional retirement account, like an IRA or 401k, at such time as you pull the assets out, you have to report those assets as taxable income. So if I pass away and I have a retirement account and I leave that retirement account to my wife, she gets the retirement account. Whenever she takes required minimum distributions or other distributions from the account, she will have to report the income on her tax return. That income tax consequence does not eliminate or go away simply because I died while owning the retirement account. Until a couple years ago, we had some rather complicated rules related to IRAs, where if we were trying to leave the IRA to someone other than a spouse, we would want to leave it to that individual either outright or in a specialized trust that would allow the individual to take required minimum distributions over their entire life expectancy, which of course is a benefit, because if you're getting tax deferred growth and income within the IRA and you don't need the money, you'd like to keep it in the IRA and avoid reporting the income for as long as possible. Recent changes in the law have made it where for someone other than a spouse, disabled individuals and minor children, that ability to have what we call an inherited IRA with a stretch payout over the beneficiary's lifetime has been eliminated, and the payout is now, generally speaking, for individuals other than a spouse or a few other categories, you have what's called a 10-year payout, meaning that if you inherit an IRA, you must pull the assets out of the IRA within 10 years after the death of the individual who you inherited it from. That's made, I think, planning a little bit easier, because we don't have to always have these complicated trusts that a client may not like the exact terms just to get the inherited stretch out. We can really look at sort of non-tax goals. If I were, one point though I would make about IRAs is, if your intent is to leave your assets to a spouse, you should definitely make sure the spouse is the designated beneficiary of the IRA. Surviving spouses still have substantial benefits from an IRA if they are the designated beneficiary. Namely, they can roll it over into their own IRA and avoid required minimum distributions until such time as they would need to take them. The second tax point is acknowledging that IRAs have an inherent tax liability. We can do some planning that would avoid or minimize the tax. For example, if an individual has charitable intent and they would like to name charitable beneficiaries, at their death, we're going to recommend that they name the charities as the beneficiaries or partial beneficiaries of their IRA. And the reason for this is that the charities can receive the IRA assets, but they don't pay income tax. So they can receive 100% of the IRA that is distributed to them. On the other hand, if a child receives an IRA or a spouse and they take the money out, they're going to have an income tax consequence. So they will not receive 100% of the funds that are pulled out of the IRA, since they will contribute some of it in tax. You can also try to minimize an overall family tax picture if you were to leave the IRA to certain beneficiaries who have lower income tax rates than others. So if you have a child who's a world-renowned plastic surgeon and you have a child who is equally successful but is a public school teacher, those two children are not going to have the same income tax rates. You might choose to leave the IRA to the child that is the school teacher, knowing that when they report the income, they'll pay less tax. It gets a little complicated because it's hard, if you want to treat your children equally, to factor in the tax consequences. But those are sort of the considerations that we think about when we're planning around IRAs or retirement accounts that have inherent tax liability. I'm going to pass it back to John, and he's going to talk about sort of the things we're reviewing in older plans that have come up because of the changes in the tax laws along the way.
Thanks. And when we talk about older estate plans, they're not that old, because this, the exemptions not too long ago were 3.5 million, 1 million. If you go back 20 years, it was $600,000 instead of 11.5 million. So particularly with married couples, we still see a lot of estate plans, whether it's in a will or revocable trust, that say something like, upon the death of the first spouse, there will be a certain amount or fractions set aside into something that's usually called a family trust or a shelter trust or something like that, for the benefit of the surviving spouse. So in other words, instead of leaving everything directly outright to the surviving spouse, there's this formula of some kind that leaves a portion in trust for the surviving spouse. And those plans were almost universal for married couples who had over $1 million or a few $1 million not too long ago. So we see a lot of them. But these days, that type of planning is, depending on the total net worth, not doing any good at all for estate tax savings. It's just not needed anymore for estate tax savings. And in fact, may be doing harm in not maximizing the so-called step up in cost basis that the children would ultimately receive after both spouses die. So, you can't just automatically assume that that kind of a trust is wrong, because there are certainly a lot of couples out there for whom that type of trust tax planning is still perfectly appropriate and suitable and necessary to save taxes. But a lot of the plans that have that, it's not suitable anymore. And we can't tell that just from reading the plan. We can see what the plan documents say, but in evaluating something, you don't know the whole story until you, of course, know about the client's assets, and not just the total value, but a little bit more about what types of assets they are. And also, perhaps most importantly, what are this couple's own personal goals for their estate plan, both in terms of what they want to leave to each other and then to the children or other beneficiaries after they both die. Is there charitable intent there? All these things come into play. So you kind of have to examine the entire situation as a whole to determine whether those plans need to be updated or not. But when they do need to be updated, frankly, as part of our job, it's a very satisfying thing to do, to tell a client that not only can they simplify their plan in terms of understanding it better, but that after the first spouse's death, the survivor will have a much easier time. They won't have to administer this other shelter trust that was in the plan before. They'll save money because of that. The kids will save money later on. Everybody's happy. And we get to write a simpler plan, which is always nice too. So if your plan hasn't been reviewed in a number of years, that's certainly something to look for as a married couple. And then we've touched on this before, but it's worth doing because it's so important. If you have any IRA accounts that name a trust as a beneficiary, either primary beneficiary or contingent beneficiary, or for goodness sake, if you have any IRA accounts that name your estate as a beneficiary, please go see an attorney to see if that is a suitable arrangement, because it might not be. I think I'll stop there on that topic, John. Go ahead.
I'm going to talk about a slightly different income tax consequence or discussion, which is discussing how you can avoid or reduce or obtain deductions for income that is earned during an estate or trust administration. And one of the questions that I get almost all the time from beneficiaries is, well, you're telling me that I'm going to get this money. Do I have to report it on my income taxes? And my answer is no, not, well, kind of, maybe. The answer is this. If you get $100,000 in a money market account from your father, you do not report $100,000 worth of income on your income tax returns. But that money market account has been earning interest while your father was alive and in the interim period after he passed, before the assets were transferred to you. And someone has to report that income that was earned, the interest that was earned on the account. So when someone passes away, their assets continue to earn income. They get dividends, they earn interest. Sometimes the estate or trust may sell something, and although there is an adjustment to the basis, sometimes there's some gain or loss. Estates and trusts also have the ability to deduct certain expenses related to the administration against the income earned by the estate or the trust. So just because an estate is earning dividends does not necessarily mean that it will have to pay tax. It's just like an individual. It reports its income, it may have deductions. So the planning that we try to do is we want to make sure that within a tax year for the estate and the trust, that if we have expenses and income, we can try to marry those up so that the dividends and interest and income that the estate or the trust have to report, that we can have a corresponding deduction that means that no tax is paid on that dividends and income. Also, it's always likely that an estate or trust will have some expense that would be a deduction. So if we're doing good planning, we want to incur some income within the estate and trust assets so that we can take use of that deduction for the expenses and that it's not just lost. So back to the original question, what I tell the beneficiaries is, no, you don't report dollar for dollar what you receive, but you may receive what's called an IRS Form K-1 from the estate or trust that kicks out some of the dividends and interest to you, and that is what you would report on your personal income tax returns. John, do you want to talk about some gifting strategies that people may be inclined to?
Yeah. But actually, I think another topic, things always occur to you in these discussions that you need to add to what you had planned to say. With all of the changes in the tax law, both the changes that are already scheduled to occur, like with this so-called sunset of the estate tax exemption, and changes that we think may be coming down the road either as a result of an election result, either way, or just, I think that we all recognize that whether we can forecast when it's going to happen, the estate tax laws are going to change, and they seem to change more frequently now than they used to. So there has been a lot, I think, of change in the estate planning world in adding new ways to be flexible about the tax planning aspects in an estate plan. Both in terms of the tax planning that might occur between a husband and wife or a married couple, trying to maximize the use of both exemptions, but also, as we've talked about a few times, trying to maximize the so-called step up in basis among trusts. We haven't really gotten into generation skipping planning in this discussion, which is when you try to leave assets in a trust that might benefit your children for their lifetime, but then pass on upon their death to their children without being subject to estate tax again in your children's estates. So you can set up these multi-generational, can certainly be more than two, long-term generational trusts that avoid the estate tax regime as they pass down the generations. So another thing that we're looking for in reviewing older plans is what additional flexibility can we build into this plan in case the law changes, either in ways that we can kind of see coming down the road now, or in ways that we just have no idea may be happening or not. You know, who knows? The United States may change to the Canadian estate tax, which essentially, I believe, just treats death as sort of a deemed sale of all the decedent's assets, and the estate pays capital gain as if everything had been sold, but there's no other estate tax. So, you know, there are lots of different ways that the tax could be changed, and we can't foresee everything. But one thing that I've had a lot of clients call me about lately over the past year or so, and especially accelerating in the last few months, is you know, the call goes something like this of, oh, I think that if the Democrats win control of the Senate and the presidency, that there's going to be new tax law passed, and Biden's materials have said that he would intend probably to lower the estate tax exemption. Hasn't said exactly to what. So I'd like to go ahead and use up the current high exemption before it maybe gets lowered. So let's say, just hypothetically, of course, who knows what it would be, but let's say that today it's 11.5, and that in the future, a couple of years, it might go down to, say, 3.5 million per individual. I don't know whether those numbers are accurate or not. So I have folks saying, you know, I'd like to go ahead and give away that excess portion now, so that when the exemption goes down, I haven't lost my exemption. And that is certainly a legitimate planning consideration for the folks who can afford to do that. Thing to keep in mind, though, is that in that hypothetical, if the exemption is going to go down to 3.5, you've got to give away more than $3.5 million before you've even started to do any good, before you've started to use up your exemption. Because let's say that you just gave away $3.5 million. And then under current law, you started with 11.5, and now you've got 8 million left. And then next year they lower it to 3.5 million. Well, all of a sudden now you have 0 exemption left. So the gift that you gave away this year only used up what you could have given away next year anyway. So you have to give away more than whatever you think the new exemption is going to be. And of course, there are not too many people who could afford to give away more than 3.5 or 5.5 or whatever you think it is going to be. But we're certainly seeing some of that. And for the folks who can afford to do that and are willing to make such a gift, there's certainly a good argument why that might be a good idea. Although, of course, there's always other considerations, like, you know, as John mentioned earlier, when you give away an asset, the recipient takes a carryover cost basis, not the adjusted step up in basis that they might get through inheritance. So that's certainly a trade-off. There are lots of law changes, though, that might be coming down the road. You know, another one besides just the exemption level is changing the possibility for valuation adjustments due to, say, a minority interest in a closely held business, or a minority interest in a piece of real estate that you're only a 1/3 owner of, something like that. John, any closing comments?
I would say, one, I think that while the tax issues are sometimes hard to comprehend or boring to discuss, one thing that interests to me is there's real money to be saved, both in the planning process and during the administration process. And for me, one of the more rewarding things of either of those is when I can show the client when I'm drafting their documents, or show the beneficiaries when they're receiving their assets, how just by, without changing what the client's intent was, but just the way that we implemented it or the way we handled the administration, we saved real money and put more money into the hands of their beneficiaries, whether it's their children or whether it's charitable organizations. The other thing I'd say is we've got a talk coming up later in November that has to do with both revocable trust and various types of irrevocable trust. And without getting into too much detail there, I would just say that most of those irrevocable trusts have, at least as a part of their component for why people do them, is either estate tax savings or income tax savings. So when you tune into that talk and you're thinking in part, why do we have all these different types of trust? Well, it's because we're trying to help people either save on estate tax or save on income tax. So thank you guys for listening, and
Thank you.